Hi, this is Lawyer Dan with today's Legal Scrubs video and podcast. And today's topic is going to be on trade secrets. Now, there are a couple of recent developments dealing with trade secrets that you may or may not have heard about. First is, just yesterday, there was a decision in a federal court in Delaware involving the big global company L'Oreal, which is headquartered in France, and a small company, relatively small company, called Olaplex, which it comes from California. Now, L'Oreal is a big name throughout the world. No telling how many employees and people work for L'Oreal. Olaplex has about 30 workers. It doesn't have a large advertising presence in the world, but what it does have is it has some trade secrets that are very, very valuable. Several years ago, I believe this goes back to 2015, Olaplex came up with a process for protecting hair during the bleaching process. It has something to do with bonding proteins or hairs on your head when you do a bleaching process cosmetically to bind the proteins together to protect the hair during bleaching. And anyway, L'Oreal and Olaplex talked about the possibility, at least, of L'Oreal acquiring Olaplex. And during the course of the discussions and the possible negotiations, Olaplex made available to L'Oreal to see some of their Olaplex's trade secrets in connection with this protective process that's used in the bleaching of hair. And for whatever reason, the deal never went through. L'Oreal did not acquire Olaplex, but L'Oreal at some point developed or began selling products that were had the same basically the same types of protection that Olaplex's processes had. And Olaplex sued L'Oreal and said that it had breached its contract with Olaplex, that that L'Oreal had infringed upon its patents, and that L'Oreal had stolen or misappropriated trade secrets of Olaplex. Now, like I said, just yesterday, a federal jury in a federal case in Delaware decided in favor of Olaplex and awarded Olaplex damages against L'Oreal of over $91 million. Of that award, it's my understanding that it was broken into three categories. Some damages were for breach of contract, some damages were for patent infringement, and some damages were for misappropriation or theft of trade secrets. And with respect to the trade secrets damages, I believe that amount of the $91 million was about $22 million. So that's one case that has just come out. Like I said, this happened yesterday. I'm filming this video and doing this podcast recording today on August the 13th, 2019. So this just happened August the 12th. Another recent case involving trade secrets was a U.S. Supreme Court case that came out, a little over a month ago. I think it was June the 24th. And this was a case involving Food Marketing Institute versus Argus Leader Media, which Argus is a newspaper or a newspaper company, and it had tried to get data that the U.S. Department of Agriculture had on what retail stores were participating in the food stamp program and how much volume of food stamp redemptions happened at each particular store. They sought this information, the newspaper did, through the Freedom of Information Act, or FOIA. And although the information pertaining to which stores participated in the food stamp program was provided to the newspaper company, because the information about how much in the way of food stamp redemptions occurred at each particular store was given to the Department of Agriculture as confidential or secret information from the stores. Under FOIA, or under the Freedom of Information Act, an exemption was cited or stated that said that this was secret, confidential information that could not be provided under the Freedom of Information Act. The newspaper company sued. It eventually made its way to the U.S. Supreme Court, and the Supreme Court, in a decision a little over a month ago, written by one of the newer justices, Justice Gorsuch, said that if information is provided to the government, to a federal agency, as confidential or private, and that is essentially a trade secret of the private companies providing this information to a federal agency, that it is exempt from disclosure under the Freedom of Information Act. So what do these two cases have in common? The case involving L'Oreal and Olaplex, and the case involving Food Marketing Institute and Argus Leader, the newspaper company. Well, there are several things. The first thing is trade secrets, information that a business may have that is valuable to that business in its doing its business, making profits, the kind of information that the company would suffer if the information was made public rather than kept private. That information, those trade secrets, are valuable. In the case of the L'Oreal case, a jury decided that the trade secret damages on a misappropriation claim to this particular company were worth $22 million. In the case of the Supreme Court case involving the Food Marketing Institute, trade secrets were valuable enough that the federal government refused to disclose the information to a newspaper based on an exemption under the Freedom of Information Act. So point number one is, if you run a small business, or you have a business that has private, secret, confidential information, that information can be extremely valuable. And that leads to the next point, which is point number two, you need to protect your trade secrets. Because if you allow your trade secrets to become public, then there's nothing to protect. You don't have a registration with respect to trade secrets. The way it's protected is because a company keeps its trade secrets secret. So your trade secrets are valuable, and two, you must protect them. So who do you protect them against? And that's another point that doesn't necessarily come from these cases, but you need to keep in mind. You need to protect your trade secrets from potential competitors. That was the case between Olaplex and L'Oreal. They were talking about a potential transaction where L'Oreal might buy Olaplex, so they were in discussions. But when you have a potential competitor who may get access to your secrets through negotiations or through a potential deal, you're going to want to make sure that you have very, very good, tight confidentiality agreements, and you make clear that you're only disclosing this information under a confidentiality agreement, and it cannot be used. And so that's one category of persons that you want to protect your trade secrets from are potential competitors. Another category is if you have employees or other people who work for your company who have access to your trade secrets, you want to make sure that you have agreements in place that impose an obligation on those people to keep your secrets secret. To the extent possible, you want to not disclose information to anyone who doesn't have a need to know it. And when that person or persons leave your company, leave the employee of your company, you want to make sure they don't take copies with them. You want to protect your access to your computer systems. You want to make sure that someone doesn't just walk away and use your trade secrets. Another point is that if you do have trade secrets and someone does take them, misappropriate them, and try to take advantage of your trade secrets for their benefit, you have rights. You can file a lawsuit, you can bring an action, you can seek to protect your company against that infringement or that taking of your intellectual property, your trade secrets. There are in all states trade secrets laws, and now there is, for the past several years, there's been a federal statute that protects trade secrets, so that you may, in the right circumstance, may even be able to bring or want to bring, if you have an infringement case or a misappropriation of trade secret case, you may want to consider whether you would bring a case either in your state court or in a federal court. Just to summarize, number one, trade secrets are valuable to your company, and you want to protect them. And the way you protect them is that you keep them secret. You're careful not to disclose the information to anyone who doesn't have the need to know it. And you want to have good agreements in place that impose obligations on anyone who gets access to the trade secrets to not disclose it themselves, not to disclose the secrets themselves, not to use the secrets, and to not make copies or to take any of your secret information with them when they no longer have a business relationship or are working or employed by your company. And lastly, if the worst happens and someone does take or seek to use your trade secrets, you want to know that you have rights to go back and seek damages, and also to seek injunctive relief against the person or persons or company that has sought to take your trade secrets. So we think about intellectual property usually with trademarks and patents and copyrights, and those are certainly components of intellectual property. But another important component of intellectual property that has great value to your business are often trade secrets. All right, so I hope this helps. If you have any questions, don't hesitate to contact me. You can find how to contact me at my website, dpslegalcounsel.com. Just give me a call. There's a way to schedule a consultation with me at the top of my home page, and let me know if you have any questions, and we'll talk to you next time, and until then, we'll see you. Have a great day.